Okay. I know we have competing motions this morning, and the problem was, Mr. Dillon, I know you had the to appoint um, the next friend, but in that you had one of the persons who was a party to the action, and then Ms. Corpus's response was that you can't really have a party who's an individual who's a party to the action to act as the next friend in the same instance. So that was the concern. Because I know I put her motion over because we didn't have the motion for the next friend. Then when we got the motion, it indicated that the request was for one of the parents, and one of the parents, both of the parents are actual parties to this action. So what's your response to that, Mr. Dillon?
My first response is the one that we had filed a while back, indicating that we did not believe that there was impropriety. I think that those types of decisions, that this alleged, conflict of interest, I suppose you could say that a parent has similar conflicts of interest raising their parents or raising their children all the time. Whether to buy themselves clothes or their child clothes, feed the child, or go to the place where the child wants to eat, or go to the place where the parent wants to eat. These are decisions that are made all the time, that a parent has to deal with. And I think then that the mother is an appropriate party to be the next friend. I don't see any case law or any rules that suggest otherwise. However, we did earlier today file an amended or a supplement to our motion that indicates that the grandfather would be happy to take over if the court was, felt that it was necessary not to have the mother be that next friend.
Ms. Cox?
Your Honor, first of all, I've never seen a supplement. I mean, we've been in this litigation since 2023. Plaintiff has failed to appoint a proper representative. Counsel just made a representation to this court that there's no court rule or case law that suggests the mother couldn't act as a next friend, and that is false. As articulated in our response to plaintiff's motion, court rule MCR 2.420 in sub B sub 2 clearly states that if a person is in an action and shares an interest in the settlement or judgment, they cannot act as a next friend, which is what we have here. We had our motion for summary disposition also filed a while ago. Plaintiff failed to properly respond to that motion, raising any genuine issue of material fact. So that motion should have been granted for those reasons as is. This honorable court gave plaintiff yet another chance to get their act together. And now here we are, the day of the hearing, where plaintiff is just now filing supplemental pleadings, trying to appoint a separate individual that I haven't been made aware of, haven't seen. For those reasons, Judge, I think the plaintiff's motion for next friend should be denied and our motion for summary disposition should be granted.
Well, the fact of the matter remains is that, and I don't know, we're still in litigation. And I know we got a settlement conference today as well. I don't want to, like I said, I'm not fully aware of this child's position here, and just to hinder the child's ability to proceed on this, which is a minor technicality, the court isn't prepared to grant the summary disposition as to this minor for the sole purpose that we don't have the next friend appointed. This case can proceed. The only reason that we do need a next friend is in the event that there is a settlement reached in the distribution of the proceeds. And I understand that's why we probably, and it's not advisable to have the mother, who is a party of this action, as the next friend. But, and Mr. Dillon, I don't see where you filed anything. I don't see
It,
it.
it, it was just this morning, and it's Gurpreet Singh is the individual who I spoke with
Yeah, but like I
today.
said, if you filed it this morning, it definitely wouldn't hit because it has to go through the county clerk's office, then it has to come to my clerk, and then it has to get, well, when it goes to the county clerk, and they usually have over 1,000 pleadings to enter. So you filed it this morning, it'll be 48 hours before it hits. And I know that I understand and appreciate Ms. Koch's position because we have been going around the block with this. And we knew you knew a long time ago that the mother wasn't the proper party, Mr. Because I put this over from, I know somebody can tell me, this was initially up July the 10th. So
So, yeah, Your Honor, the uh, AJ Veer is 17 and 8 months, 17 years and 8 months old. He would much prefer to have his mother be the next friend.
she cannot, because she's a party in interest in this action. She cannot, she cannot.
And and we have uh, and I'm representing to the court that Mr. Gurpreet Singh, the grandfather, has offered to serve in that capacity, and I'm representing to the court that I have filed the document um, that Mr. Singh authorized, indicating that he would be responsible for costs as is required under the uh, next friend rule.
Right, but unfortunately, you just filed that this morning, and that's not in front of the court. I don't, I can't. The court operates from reviewing pleadings, and this is a situation that's not just a matter of fact, like a discovery request or extending a deadline. This is something that the court has to make a concise ruling on whether or not to allow this individual to be the next friend. And like I said, this case is it's because you all are getting a trial date today. In all actuality, it'll be at the end of the year. But at this juncture, I'm teetering on granting her relief because Mr.
I
Dillon, let me finish. This, like I said, this has been pending, and she filed this. It was put on the docket for July the 10th, but she filed this March 25th. This has been an issue, an ongoing issue, since March, Mr. Dillon. And here we are in August. And like I said, you've been put on notice, and you were put on notice as to her position. She gave you the court rules and the case law to substantiate it. So it was clear pretty much on his face, and the court gave you an opportunity to get somebody back. And I told you it wasn't going to happen. That's why I told you to get somebody else when I put it over from July the 10th. I don't know why you came back and expecting the court to do something different when I basically told you what I was going to do, and the only reason I put it over was for to give you an opportunity.
Your Honor, I did not have that understanding, but and I'll tell you the other part of this though is that I do have some language barrier with respect to communication with the clients. They English is a second language for them, and I do have some difficulty with respect to that. We did, in fact, for example, for Herinderjit, we had a interpreter for his depositions. So I apologize to the court. I, I, uh, I still don't know that I understand completely how
Because
the
they're sharing in the same disposition. They're sharing in the same settlement. They're the
I
same in the same action. It seems patently clear to me. I don't understand because it and she's presented you with the court rule. She's presented you with the case law. There's undue prejudice, and in terms of being able to resolve and act on the child's behalf without any appearance of impropriety when she's to share in the settlement proceeds. Because I don't, and
you,
I don't know
well,
where we are.
I think there is a deference to a minor who's 14 years of age or older to accept their preference.
But the
And
thing is, you can say accept their preference, but this is a legal issue. This has nothing to do with preference. This is a definitive legal issue. Their preference, that child's preference cannot be honored in this situation because of the fact that the mother is part and parcel of this action and to share and is looking to share in the same proceeds. It's a legal issue. It has nothing to do with the child's preference, Mr. Dillon.
uh,
And like I said, if
and that
you, I
that
can
that being
deny it.
said,
I can, Mr. I can deny it. I can grant a relief. Mr. Dillon, I don't. you're debating an issue that I really made clear the last time we were here.
Well, that's Your Honor. I have at least allow me to make an oral motion that Mr. Gurpreet Singh will serve in this capacity. He is the grandfather. He's available by phone um, to converse with us um, to the extent that he can, and um, that's the individual who can serve as next friend.
But you're saying to the extent that he can, what you should have, and like I said, I don't like practicing law for people. If there's a language barrier, you could have prepared an affidavit. That's
Um,
plain and simple,
he
but
did. I do have a document, the amended motion that's signed by him, indicating that he would accept this role.
Your Honor, I'm going to object to an oral motion. I don't know if this individual is competent
I
to
know.
stand as next friend. This is just, like the court said, this is highly prejudicial to defendant. I think the motion should be denied and the summary disposition should be granted. This issue has
Your
been
Honor,
ongoing
all that's
for
going
the
to do is
year and a half that
necessitate.
this litigation has been pending. And like this honorable court said, plaintiff was made aware of this issue since March. And I even identified it in my responses, in my replies, in multiple pleadings. And yet here we are, plaintiff making an oral motion to prejudice defendant once again.
Well, I don't think anybody's prejudiced, Your Honor, and quite
Well,
frankly, the
yes,
only
we are
prejudice.
because one, let me tell you this. Like I said, this case is a year and a half going on 2 years old. This case was filed December 7th of 23. So it's more than a year and a half now. So, and here we are, as it was brought to your attention. She filed her motion March, I think it was March 25th when it was filed. And one, it didn't get on the court's docket because of the court scheduling till July. And she
Yeah,
provided your response. I don't know when she provided you with her, let me see, her response.
My
Your Honor, the
reply, Your
court.
Honor, was on July
I
1st, 2025.
I'm
would
sorry, Ms.
also like to
Focus.
point out
My
that,
reply would have been July 1st of 2025, which is when plaintiff was put on notice of the issue. Again.
Your Honor, I would just point out that the next friend rule is not the rule that opposing counsel is citing. She's citing rules regarding guardianship and conservatorship. And there's nothing that would prohibit the mother from serving in this capacity. If the court wants to appoint
And
the
I
grandfather
made
instead, I mean,
because I made my position clear that there's an appearance to alleviate the appearance of any impropriety, or because what the next friend is supposed to be an independent person, and how can she act independent if she's potentially going to share in the same settlement proceeds? That's the
if
problem, because
if
we have not entered into a settlement agreement. I don't know. Yeah, I understand the whole entire family was in the vehicle at the time, but
if there were the appearance of an impropriety, which I don't believe there is, but if there were, the court could certainly use a guardian ad litem if that were the case, or the next friend could be altered from the mother to the grandfather at that point. Uh, this is with all due respect, Your Honor, the court rules that are being cited here are with respect to guardianship and conservatorship, and not the rules regarding next friend. And it is appropriate to have the mother. It's appropriate to have an oral motion to appoint the grandfather. It's appropriate for the court to review the document that I filed, albeit just
I
this
can't.
morning.
I don't have it. I can't.
Yeah,
I can't even look at it. I don't know who this man is. I don't know what his
he,
abilities are. Like you said, there's a language barrier. Um,
he is
one one thing,
he.
one
I mean,
thing, one thing I think I am going to do is appoint a GAL, and those that the GAL's fees are coming out of the proceeds. GAL has to be paid. So if because when we get to the point where there's a settlement, I'll appoint a GAL. But we still don't have a next friend. So,
I
you know,
understand.
But Ms. Cooks,
Your
I'm
Honor,
appointed
I'm representing to the court that I have a grandfather who has indicated that he would accept the role, and that I have filed this document, and I can show the court the filing if it would if it would just if that would satisfy the court in any way.
But
Um,
like I said, I need an affidavit because like you said, there's a language barrier and I need to know and understand that this gentleman understands what his responsibilities are. So, filing a pleas, but like I said, I'm still appointing the GAL and the GAL's fees are coming out of whatever settlement is reached. So
Understood.
um I'm gonna appoint a GAL and I'll get that person to you. I'll have Miss Clifton um email you that hopefully later today, Ms. Cocos.
Thank you, Your Honor.
Okay, and like I said, the GAL's fees are coming out of the whatever settlement proceeds this um the young man gets. So, and that's a cost that comes off the top. Okay, so I'm basically Ms. Cocos denying the motion for summary disposition and denying the motion for next friend, but appointing the GAL. And like I said, I'll get the and get that, have Ms. Clifton email you that before the end of the day. So, like I said, we have, that being said, are we even in a position to have a settlement conference discussion today, or do I need to put this out another week or so? Ms. Cocos?
Your Honor, my client did not want to offer anything as to Ajavir because of his lack of capacity. So if the court wants to adjourn it, for me to have a conversation with them to see if any offers can be made now that a guardian will be appointed by the court.
Okay, I'll let me put this out. Let me check 1 second, please. What about next Tuesday, the 26th at 10:15, 10:30? Either one of those.
Your Honor, I do have a deposition starting at 10, but I would be available anytime before that.
I'm traveling, I'm afraid,
On
on
the
the 20.
26th,
Yes,
which are you leaving town on the 26th?
actually, I'm returning
Mm,
on, but I probably won't be back until the
okay.
later in the day on the
I just wanted
26th.
to know which way to look.
Yep,
What about the 27th at 10:15?
I can do that.
Ms. Cook?
10 and 15 will work. I have my next thing would be 11 o'clock, a call, so I could do 10,
Okay.
15.
Okay, we'll adjourn the settlement conference to 10:15 on Wednesday, August the 27th. And like I said, Ms. Crocus, I'll have Miss Clifton email you the guardian ad litem's name, and then you can place that in the order. But I'll try to get it to you by after lunch, immediately after lunch, if not before then.
Sounds good. Thank you very much, Your Honor.
Okay. Thank you. We'll see you on the 27th at
All right,
10:15.
thank you.
Thank you.
Thank you, Your Honor.
Mhm.